All right. Hello, folks, and welcome back to another edition of File Law Roundup. This one although it's March 20th, it's for the week of March 21st. So, Brad, why don't you kick us off while I deal with the
Sure. I,
technological
I
headaches
got
here?
to tell you, this is one of those weeks. There's a couple of simple ones. There's a couple of very long discriminatory allegations.
Mm.
I'm gonna open with my first caveat right out here. We only know what we read, and we don't even know if that's correct, right? This is just what we get. So we're gonna comment on it, but nobody should take offense. We're not saying anything true. We're just relaying allegations and using all of this more as lessons, right, for everybody. So, for example, let's start off with one. And there's a couple of simple ones. There's a couple of, boy, we can spend hours just reciting the facts, and I'll do my best to kind of summarize some of it. So we have the Texas Court of Appeals. The Texas Court of Appeals ruled in a line of duty death accident case. And what they said is the case can proceed against a firefighter. So here's what happened. So a Texas court, they were asked to dismiss a lawsuit, and the lawsuit was against a volunteer firefighter. The volunteer firefighter struck two firefighters after a call, and this is important. I'm going to emphasize this again. And by the way, I got to say, this is very specific to Texas, right? This whole thing, although we'll kind of extrapolate it. But so what happened is there were three volunteer firefighters. They were clearing a call, and very important to this case was that they were headed home. Now, two were in a tanker, one got in his personal vehicle. The two in the tanker pulled over. I think they were checking the tires to make sure they're okay. And as they're doing that, the firefighter who was headed home, very important for Texas, this fact, in his own personal vehicle, not in a fire truck. He was clearing the scene in his personal vehicle, headed home, and he strikes and injures two firefighters, kills one of them. So they sue the parents, I presume, of one, and the injured firefighters sue the driver, obviously. And I don't know if they didn't sue at all, but at least this suit wasn't against the fire department. I don't know. I don't know if you know whether there was a companion suit.
I didn't see anything about a second suit, so it looks like they chose to go after the driver personally, not after the department.
Yeah, and I just have a hard time imagining that, you do it all, right? I mean, what we call in the law the shotgun approach. But in any event, I'm not criticizing. I'm just
Well, I think there might be a reason why, if the person who was driving had insurance, that you're going to try to tag the insurance, and then that way you're trying to avoid the municipality. There's a lot of attorneys that don't want to sue municipalities. I don't know if because I get calls from attorneys from people all over the country, and I'll try to hook them up with an attorney I know. And there's certain states where as soon as you say, I got an accident case, but it's against government, they want nothing to do with it.
And look, I mean, there's, sovereign immunity to explain to our viewers, to give them a little education, as we always try to do. Normally, you can't sue a municipality unless a municipality tells you can. And that's not done on a case-by-case basis. That's done decades in advance, where the state says, or the federal government says, or the military says, or, there's Federal Tort Claims Act, there's state claims acts, where the government says, listen, we'll allow you to sue us for certain things, but only if you go through several hoops. Normally, those hoops involve, you have to file a notice of intent to sue, which is a very specific document. Usually has to be filed within 90 days of the loss of the act. So you give time to the government to investigate. By the way, I worked in the state court system where you would sue the state specifically. And so people screwed this up all the time. I also worked in the U.S. Attorney's Office where they sued the government. They screwed that up all the time. So, but you have to sue within a certain amount of time. You have to say very specific things, and just attorneys mess this up. So maybe, right, either they blew that or they decided they wanted to do that. I don't know. I can't guess. But in any event, what's interesting here is that the driver said, listen, you sued me. The driver was headed home, who struck the other, said, I was acting in my official capacity as a firefighter, and you can't therefore sue me. You have to sue the fire department, the government entity, and not me, because I'm acting in my official capacity. The court comes out looking at the statute, which is very important, and says, listen, the statute doesn't include travel from the scene of a fire, right, within the definition of an emergency response. And so they said, listen, he wasn't involved in his official capacity. Now, we could talk about this forever, because I flip the facts. Now assume the guys in the tanker hit the other guy, right? They're in a fire vehicle, presumably headed back to the station. I'm curious if the court would have said, well, the call was over, so it wasn't within the definition of an emergency response.
Yeah, but they're driving a government vehicle, so I that's a good point.
Yeah.
I think it comes out a different way. I think if the tanker drivers struck the other driver, they're driving a government vehicle. Yeah, good point.
Right. In New York State, we have a workers' comp statute, and the workers' comp statute says you're acting within the scope of your duty when certain things happen. And in New York State, at least, which probably isn't that different than other states, it says going to and coming back from, right? Mm-hmm. So who knows? But Texas, very, very limited. And they said it's a case of first impression. So my bet is this gets appealed. My bet is they're going to say, listen, an emergency response necessarily includes travel to and from. I just have a hard time, but these are the worst facts possible for anybody, because he's in his personal vehicle headed home. It so shows the listeners that facts and reading a statute is so important. You can't just say, oh, he's wrong, because you got to sue in the right place. You got to sue in the right time. It is tough, and you got to know the statute.
And, another thing that we try to emphasize is that somebody can be working on behalf of government, for example, workers' comp, but not be working on behalf of government for something like this, which is the tort claims process. Same thing. There's no one definition of when you're acting on behalf of the fire department. So it really is. And OSHA may take a different view of it, and I know the FLSA takes a different view of it, assuming that you're dealing with an employee, because it would be a commute. Your return home would be a commute. You're not on the clock. Right. So at any rate, it's
and look,
interesting
case. Scope of duty is another good one. When I was 30 years ago working for the state court of claims, where you sue the state, just like here, there was a park ranger who was on duty, wearing his gun, walking around the park, patrolling, rapes a girl, and they sued the state of New York, saying, well, your park ranger raped this girl. And the judge, my judge, us, kicked it out, because they said, well, listen, he may have been working, but raping somebody wasn't within the scope of his duty, so the state cannot be liable for him. This is more akin, kind of like that, where, well, what was the scope of his duty? And in this case, the statute defines you're on duty when you are driving home or not when you're driving home. I just, I don't know how strict they're going to be, but I think this gets reversed. But what do I know?
It's the Court of Appeals. So the trial court ruled it the exact way that you explained it. The Court of Appeals did. So then it's up to the Texas Supreme Court. So,
and I think it's a big case. I think defining, what that statute means, what the legislature intended, and when are people covered is a big deal. Hopefully it goes up, but I don't, I don't know.
Yeah.
Okay. So another easier one, but let's stay on the
Stay easy. Stay easy.
I like it. Because when we get to these discrimination and harassment ones, wow, it's too late. So here we have a Virginia firefighter who pled to a lesser charge, right? He was charged with something, and then
reckless driving. He's charged with reckless driving.
Yep. And it's important. I got to tell you, there's a lot of these, volunteers and career firefighters better pay heed to this. And we had one, I think, 2 weeks ago. I mean, these keep coming up, where firefighters are driving a fire apparatus in an allegedly reckless manner. right? And they kill or injure someone and they're charged criminally. So here you get a 25-year-old, right, who's driving the volunteer fire department's rescue or engine, engine, right?
Engine,
So,
yeah.
15 tons, 20-ton engine, and allegedly was going, 70 miles an hour, tries to swerve at the last minute to avoid rear-ending a stopped vehicle, and then collides with another oncoming vehicle. So he takes a reduced plea. So what you noted and the blog is that the reckless driving charge would include a potential sentence of up to 12 months in jail. So, here's why somebody would take a reduced plea of improper driving. The important part for this, you can bet there's going to be a companion civil suit and a plea to a lesser charge, but in response to the greater charge of reckless driving is going to be at a minimum some evidence of his negligence. But, it's going to be hard to imagine they're going to fight too hard to defend this. It's not like he was responding to an emergency. I think he was headed back. Right. He's going back to quarters.
Mm-hmm. That's two cases returning after a run. So
one they kill someone else, one he kills, his
or injures somebody. Yeah.
Okay, look, one we can dispense with really quickly, two we can dispense with really quickly before we get into the thick of it. Here's a former Louisiana fire chief. He's charged, that's factual, with stealing about $40,000 in fire department funds. That's the sum of it. He's just charged. We don't know what happens, but there was apparently a year-long investigation by several agencies. I want to tell you a couple of things on this. And I always lecture at my conference, and Curt, we should probably put together, because I'm going down to Texas, interestingly, to lecture on the same thing soon, about how to protect your corporate funds. And I do about a 2-hour lecture on it. We should do it on your, avenue nationwide. And I'm going to just say a couple of things. One, it's always the one you trust the most who steals from you. And two, it's more your fault than it is theirs. Because we treat the person who steals as, he would never do anything like that, not so-and-so. And again, I'm not saying he did it. But generally speaking, when there's theft, we're always so shocked, like, oh my God, I can't believe he did it. Well, the answer is if you would treat everybody who has access to funds as if you didn't trust them, and you internally audited them and reviewed them and look at all the accounts constantly, and I won't go on for hours, it wouldn't happen. But people steal. And look, I believe that bad times make good people make bad choices, right? Bad times make good people make bad choices. Maybe something was going on bad in this guy's life. I don't know. But there's always something that pushes someone to steal, oftentimes more than they're just a crook. But the common theme always is the department let the community down by not really having good standards. I'm not saying that what happened here. I don't know what happened here. I'm just saying we need to be auditing and investigating every single month and reviewing bank statements and bank accounts. This should never happen, and it's getting worse. And the problem is, if a plumber stole money from his plumbing company, it would never make national news, but the fire chief does it, bam, because we're in a public trust position, right? So.
Amen.
Yeah. Okay. That's my preaching, but theft kills me. And okay. Last one is, or not last one, easy one. When I take a breath, is the 19-year-old was charged with arson. We know that there are a lot of firebugs in the fire service. All I know about this was he was charged for lighting a hay barn and grass field on fire. One motive was he was bored. Another motive was he was angry. That's all I know about that part. So, you ready to get into the hard one?
Well, yeah, let's jump into the deep end here. Where do you want to start?
Let's start with Houston. And I went to Louisiana. Well, I actually did go to Louisiana because I went to school at Tulane. First, let's talk about the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals has a lot of reputations, very progressive, very conservative. But
that sounds like the opposite.
The opposite.
Yeah,
they got Judge
progressive. They're progressive and conservative.
They are. They're it's hard to Trump likes them, and So COVID, the test cases liked being there if we're kind of anti-testing and stuff. But okay, so I'm not trying to get off, but let me start with that. Before we get into what's alleged to have happened, let me talk about the elements in Louisiana of a hostile work environment claim. So
which one are we on? Houston or?
Oh, I'm sorry, Houston. I don't know why I keep
Okay.
saying Louisiana.
Yeah.
I think I'm just Anyway, okay,
Yeah.
sorry guys.
You've been tired. What have you been doing all day?
Not as much as you've been doing. I got a conference coming up in a week. We've been writing lectures. Okay.
Yeah.
So to state a hostile work environment claim. So again, I wanted to kind of get everyone's mindset into the legal, right before we got into the factual or allegations. So to state a hostile work environment claim, a plaintiff, the person suing, has to show 4 or 5 elements. First, they have to show that the victim belongs to a protected class. Usually that's easy if you're a female, right? 2, you have to show the victim was subjected to unwelcome harassment. Okay, we'll talk about that. 3, they have to say that the harassment is based on the protected characteristic. In other words, you harass me because I'm female. Now, there's a lot of protected classes and characteristics. I'm just using this one because that's what's happened here. 4, the harassment affected a term, condition, or privilege of employment. And that phrase is used in a lot of different, laws, FLSA and a lot of other different things you see in term conditions of employment. CBAs, we see that a lot. Anyway, and then 5, that the victim's employer, right, in this case, the female's employer, who's going to be a fire department, knew or should have known of the harassment and failed to take prompt remedial action. And 4 and 5 are big here. So, Curt, you can cut me off at any time. I'm going to try to give you some short, breathed version of these facts.
The facts. Here's the thing, and this is a 2020 to 2022 type of case. This is not something we saw in the 1980s, the 90s, or the early 2000s. This is cutting edge. It's not the first one that we've seen. It's not going to be the last one that we've seen, but it involves a video that a female made for
in 2008.
Well, right, but the cases are coming out now. The other case, and those who've been following the blog are familiar with the Las Vegas case, and we talk about that case quite a bit on a couple of different levels. But we've got a female that makes a video intended for a romantic partner. In Las Vegas, it wasn't a husband. In this particular case, it was, but the video subsequently somehow miraculously gets off the device it is on, and somehow, poof, it's on somebody else's device. And the facts of how that happened, we'll leave that to speculation.
Right.
But
so here, the chief and the captain get it, right?
Right.
Get a hold of the video. The captain sees it, tells the chief, and the chief keeps viewing it and requesting access to it from the captain. The captain's like, well, I don't want to keep sharing the password. And again, by the way, allegations. We're not saying these are facts, right? We're just repeating what we read. And the chief allegedly keeps requesting access and then gets access and is repeatedly watching it. And then, of course, what always happens, the plaintiff, the woman, the victim, alleged victim, finds out that people have been watching her. Right. So do you want me to keep going from here? That's a good short version of the facts.
Yeah. Well, I think one element in the sexual harassment claim, number one, it can be on account of someone's gender, but it can also be sexual based harassment as well. So there's really 2 prongs there. And then in order for the sexual harassment to be actionable, it has to be severe or pervasive. I know you live in a state where you kind of abandon that, right? I think New York has gotten rid of the severe or pervasive aspect, but under federal law, it has to be severe or pervasive.
And that's important here because it's only alleged, I believe, that 2 people, the chief and the captain, watched this video, albeit the chief allegedly repeatedly watched it. But, we're talking about 2 people and there's some, I didn't totally understand this. There's some allegation that it's not exactly her direct, right? The chief isn't her direct supervisor here, which is a little strange for that have been said. But, let's just go through what happened to her for the moment. So she finds out the video is being disseminated, mentally traumatized. She's ultimately diagnosed with PTSD. She takes her FMLA leave unpaid, and then she takes workers' comp, and ultimately it's determined by an administrative law judge that she's disabled with mental trauma. And the fire department fought that, right? But they lost there, and she was rendered disabled with mental trauma. She reports the incident to the inspector general. I guess that's like their attorney general, or who investigates. And allegedly the chief tried to delete the evidence from his emails and computer and such, which is never good, never helps. In any event, the OIG actually sustains the employee's allegations, and demotes, I think the chief and the captain a couple of ranks. But then the plaintiff asserts that after the investigation, and this is to your point that we got to discuss, she wasn't told how widely the video had been distributed by the fire department. Mm-hmm. She didn't know whether any copies of the video continued to exist and whether anybody else had it. And there were no assurances, of course, that she would not be required to work in the future with the captain and the chief. So she files in state court. Normally, the term is removed, right? It gets moved up to the federal court. And the federal trial court dismisses the suit in favor of the city.
Yeah, the district court was not sympathetic. It seemed to me, in reading the case, the district court was not sympathetic in the least to her situation.
Correct. And that court held, look, there was no hostile work environment. That's why I wanted to go up and read what the elements of a hostile work environment were for you in Texas. Sorry, not Louisiana. They said there's no hostile work environment because neither the captain or the chiefs were her supervisors. I don't totally get that, but
I don't either.
They are supervisors. Might not be your supervisor, but the chief or a chief. In any event, so they said, so the city can't be held vicariously liable for the chief's actions, meaning vicarious liability. You prove that the actor is liable, and then you get the government who ultimately pays. And then they said it was the firefighter's knowledge of what happened that led to her PTSD, not the actual conduct of her coworkers viewing the videos. That is insane for a court to say that somebody watching your sexual acts that they shouldn't have had, right, is not what leads to your I don't even know how to explain it.
So sometimes when judges want to get rid of things, they can make leaps in logic, and I got the sense that the judge just wanted this off his calendar or her calendar.
Had to. And the third one is more shocking. The judge holds, and again, this gets reversed in a minute for the most part, but the judge holds that the plaintiff was unable to prove that the theft of the video occurred at work. Who cares? Seeing the video at work, on the work's email, allegedly, right? Says the judge. And then fourth, they said that, well, the city took remedial action once she filed a complaint. Now, let me just stop right here. Generally speaking, this is true with sexual harassment. This is true with a lot of hostile work environment claims. If the supervisors and the leaders and the managers are the ones committing the wrong, the knowledge on the part of the municipality is irrelevant, right? Because the leaders and the managers are the municipality. It's one thing to say my coworker of equal rank or no rank was the one harassing me and the city or the municipality didn't know. But when the municipality's managers and leaders are the ones doing the harassment, or in this case, allegedly creating the hostile work environment, knowledge of the city, generally speaking, should be irrelevant.
It's assumed. Right. And Brett, that's an important point. I emphasize that when I do my HR training, we do sexual harassment training, that even the lowest ranking officer, if it's a lieutenant or captain in your organization, Once they're aware of allegations, it's as if the mayor is aware of it or the fire chief. I mean, you are a manager for that purpose.
Yep.
And once you're aware, and a number of lawsuits I've found, they even call firefighters. Like if they know that a firefighter has served as an acting lieutenant, in the complaint, get this, Brad, in the complaint, they call that person throughout the complaint an acting lieutenant. They don't call him a firefighter, just to kind of emphasize that the person had supervisory skills or supervisory authority over the plaintiff, and then they just kind of emphasize that. I'd file a motion in limine to try to prevent that kind of discussion, but that's what plaintiffs' attorneys are doing.
And there's a reason for that. When you're the reason under the law is when your supervisor or somebody even higher up is the one doing the alleged wrongful conduct, the point of reporting it, A, is meaningless, and B, who are you going to report it to? Yeah. Right. And that's part of why the protection is there for the employees to say, hey, when the government's harassing you, you don't have to tell the government. They already know.
Anyway, I forget if it was this case or the next one we're going to talk about, but one of them, I think it was this case, the trial court actually talked about the captain and the district chief, I think his title was, as colleagues. They referred to them as colleagues. They're not colleagues, they're supervisors.
I don't get it. Fortunately, the Fifth Circuit Court of Appeals, right, takes issue with most of the decision, most of the conclusions, and reverse it, and finally gets it right, saying, look, the captain and chief are ranking officers, and basically says this is going to a jury, right? And ultimately, it's going to the jury. I hate to say this, I teach at the State Fire Academy all the time. I teach the Fire Officer 3 course, and I say, listen, I said, there's a big difference between, lower level judges and higher level judges. And theoretically, anyway, the higher you get a little more neutral because you got a bunch of judges, but you get a little higher, I don't want to say intelligence level, but in any event, I was blown away. Frankly, I thought this decision was somewhere between, and I'm not saying anything to the defendant or the plaintiff. I'm talking to the court. I thought the decision was somewhere between stupidity and insanity. I don't know where that line falls, but if the chief and captain theoretically have nothing to do with this case, if a chief and captain are colleagues of a firefighter, Jesus. It would have turned every case on its head. Okay. I don't, Curt, you got to help me out. I got it, but I don't know how to deal with this next one. Let's talk about the Norfolk. All of these are so long. How do you want to deal with the facts?
Yeah. Well, I actually talked about the Norfolk one in last week's blog. I know you were in court, and so we can, anybody who's interested, but the bottom line is this female fire investigator alleged initially in 2019 that I think the case had its origins in 2017, but she filed suit in 2019 alleging that she was being discriminated against, harassed and discriminated against. And that case garnered quite a bit of media attention. So the case ended up getting settled, but with the media attention and the fact that she filed the lawsuit, she claims that she started to get retaliated against. Okay. So the next thing that happens was she settles that case and then files a new case. So this is her second lawsuit against the Norfolk Fire Department, Norfolk Fire Rescue, alleging now it's retaliation, whistleblower violations. She's claiming that, once she reported some improper things, she was retaliated against. So the court, the case ended up in the U.S. District Court for the Eastern District of Virginia. She brought both federal and state claims, and the department sought to have the state claims dismissed. And the federal court said, no, we think the state claims are valid. And I think we talked about this one. I believe they're trying to allege sovereign immunity But and again, I know I talked about this one last time. We drew the distinction between sovereign immunity. If it's going to apply, it has to be some sort of policy setting, discretionary act that's really policy setting. Sovereign immunity is not available for carrying out policy or day-to-day kinds of ministerial acts. And the court kind of went through all of the different factual allegations and said these are all ministerial acts. None of these are policy setting. It's all, day-to-day types of stuff. So these are not candidates for protection under sovereign immunity. So
yeah, and it the distinction comes up, I won't get off, but comes up a lot when suing governments. A clerk failed to issue my license, or a clerk did it wrong. Anyway, I won't even get off there. I've dealt with so many of those. Okay, yeah. North Carolina.
Well, let's go beyond the block, because I think we're going back beyond.
Was North Carolina last week?
Yeah. Well, let's see. Let me take a look. Let me go back and.
I didn't think it was. I think it was.
Yeah, I think, that was, we covered that last week. Yeah.
All four.
So, beyond the blog, really, there's a lot of things in Beyond the Blog. There was a case out of Tulsa, that I've been following. I don't know. I think it's like 4 or 5 years, but they had a captain that was actually robbing banks on his days off. And so he's pled guilty.
Times are tough. You need money.
Oof. Well, there's an unfortunate scenario in New Haven. The deputy chief ended up retiring, and I've got some friends down there, so we're not sympathetic. Yeah, sympathetic to the problems, because I to everybody, but there's a case here that I think is troubling, and it got a lot of media attention. I didn't cover it because it's a Canadian case, but it's the LODD Fire Department. I believe it's in Ontario. And the story broke about 10 days ago. You're smiling. And
I lectured up there.
Did you?
Right now.
Why is it that fire departments that end up in lawsuits, they end up dragging one of us in, right? Yeah. And then like I again, I don't want to name names, but I end up, hey, can you come out? Yep. Okay. Oh, we really need you to come in. All right, come in. And then about a month later, there's the headline, the lawsuit, that's why we get dragged in there. Right. But, so I said, oh, well, that explains a lot. I'm glad they didn't tell me before I came in, because I might have changed the way I delivered the material. But LODD, a number of female firefighters apparently felt like they were being harassed, and their complaints weren't being taken seriously. And that suit, again, I had it in Beyond the Blog. I didn't cover it. I couldn't get I really like to get a copy of the complaint. I do cover some things, but I want to see the allegations. I want to make sure, not just go from newspaper articles. And I couldn't get a copy of the complaint, so I didn't cover it fully. But the second shoe dropped in that case when the fire chief resigned. Okay, so the lawsuit's filed about 8-10 days later. The fire chief resigns, and unfortunate. We've got links to both of those stories in the Beyond the Blog for this week. But
my favorite part, when and a lot of us will know this, is that you're involved in something as a chief, right? Your term's up, your job's up, you're gone, but you're involved in litigation forever, and you're not getting paid for it. And I got to tell you, if I'm a chief, before I'm retiring or before I'm accepting the position, you want some post-retirement compensation for appearing in anything that happened while you were chief. Yeah. The funny part is they say, well, if you didn't do the harassment, it would be, hey, you didn't convict me. I'm just getting sued, or I'm part of the suit. And if you want me to be a good witness, you better keep paying me. But I always not laugh, because I'm very personally sympathetic to it. But chiefs who leave never are able to leave, right? And their families have got to be like, wow, you retired and you're still involved.
Yeah, I think it's a negotiating point, but often when you're when you're no longer in favor. It's almost like it's almost like the king, and the king now has
Right.
decided that this particular duke is he's no longer favored, and you're trying to negotiate an exit strategy here. It's not really the time, but I as a negotiating position, I negotiate a lot of fire chiefs contracts, and I try to get that in. And sometimes the chiefs don't they don't appreciate it because it's a sticking point with a lot of municipalities. But they just want to get the job. They don't want to be viewed as a troublemaker. And
right.
I've seen too many. You and I have been out to dinner with some of them, Brad, and the challenge that when you're involved in litigation after you retire, sometimes you move it to a different state, or you've retired and now you've got to keep flying back, and who's going to pay that? And you've got to come in for depositions, and then so you want to try to negotiate something in your employment agreement that's going to provide you with something for the days that you're going to need to come back. So, right. And let's face it, Chiefs get sued. Chiefs get sued. Well, Chiefs get sued, and it's unfortunate. And it shouldn't be that way. And sometimes they get sued for things. They get sued for doing the right thing. Sometimes they do the absolute right thing. If we gave everybody all the facts, you would have done the same thing. They did the right thing, and they still end up getting sued. So
look, because it's a good place to end, because it's where you started saying that suing a municipality is difficult. Not all lawyers want to do it. So what they do is they don't always know who to sue. They sue everybody, and that's including the chief as chief in his official capacity as chief. So you're named as chief, you're still participating. And I personally know it. And it goes on forever. You're just named because we're going to name everybody in the world. But when you're done as chief, you're still in it. So I have a lot.
Well, there's a strategy too, and I've been in some strategy sessions where they're saying, should we name him? No, we want him to cooperate. Let's not name him, and then let's name this guy because he's not going to cooperate no matter what. So he's the guy we want to go after. But let's not go after him. Let's have a John Doe that maybe we'll add, and then that'll keep him on our side in this case.
Or in the middle, let's name him. But we'll make him a good offer to let him out if he cooperates with us. And that's the one that worries me the most. No. Anyway, this was a lot of fun. But I think the summary is careful driving, don't steal, don't burn stuff down. And
don't be watching videos you shouldn't be watching.
Yeah. Whew. Wow. Especially allegedly, repeatedly.
It's a 2020. And I know that the video may have gone back to 2008, but this is a problem, and it's not gonna. Wow!
I'm just putting my Chiefs hat on. I just want to make sure that to end this the right way.
Is that NFPA?
It is. This is an OSHA straw helmet,
certified. Yeah.
This is my Chiefs roll now that I wear. Yeah.
All right, cool.
See, it never leaves you.
All right. Well, that's going to do it for another edition of File